The People of Colorado versus Letecia Stauch. This case has been dubbed the stepmom murder trial, who has pled not guilty by reason of insanity. And in this video, I'm going to compare the UK Crown Court defense of insanity. And get this, a random sample of nearly 400 cases across England and Wales found that 1 in 5 involved a defendant, victim, or witness with a mental health issue, according to the CPS. And I bet you're wondering, who are the CPS? Well, they're the equivalent of the state attorneys in America, and they have been established in the UK since 1986 to prosecute criminal cases that have been investigated by the police and other investigative organizations. In England and Wales, their duty is to make sure that the right person is prosecuted for the right offence and to bring offenders to justice wherever possible. And they make their decisions independently of the police and the government. In this case, with Leticia, she is pleading not guilty by reason of insanity, and that is her defense, to killing her stepson, who was 11 years old. That's her defense, that she was insane at the time she reportedly stabbed her stepson, shot him, then put him in a suitcase, wrapped him in blankets with a pillow, then threw him under a bridge several hundred miles away from their home. And by chance, bridge repair inspectors found him. So it's strange. The defendant was found competent in September 2020, though the defendant challenged this finding of the report. So a second report was conducted and found, yet again, her competent. As she had not entered a plea of not guilty by reason of insanity at that time, the court would not be able to order a sanity evaluation. Then in November of 2021, the defendant raised the issue of impaired mental condition. So the district court ordered her to be taken to a mental health institute to conduct an evaluation report. This trial is currently going on with worldwide interest. In the UK, in a criminal case, the prosecution has to take regard of the suspect's mental capacity to be able to prove mens rea, i.e. that the act they are being accused of was wrong. And the defendant, Leticia in USA, had 2 tests which, as I've already mentioned, found her competent. In the UK, a suspect or an accused can have lack of ability to participate in litigation, but when a defendant makes a plea of not guilty by reason of insanity, they are using this as a defense. So in the Sarah Boone case, she wants to make a defense of battered woman or spouse syndrome. I have done videos on Sarah Boone, as these will require an expert to give an opinion as to the defense state of mind. So check those out, as they're really informative as to what needs to be proven. You can find them in our true crime case playlist. So what does happen in the UK? Well, to establish the common law defense of insanity, it must be clearly proved that at the time of committing the act, the suspect was laboring under such a defect of reason from a disease of the mind as not to know the nature and quality of the act being done, i.e. a delusion, and that the suspect did not know what was being done was wrong in law. And here's something that might surprise you. The prosecution cannot accept a plea of insanity. It must be reached by the court. And if it's in the Crown Court, by a jury. A defendant is presumed to be sane and should only be held otherwise where cogent evidence. That means the case is clear and logical and convincing and demonstrates insanity. So I bet you're wondering what happens if the person has been found not guilty by reason of insanity. Well, in the UK, for the first time, judges and magistrates will have guidelines to assist them in sentencing in this difficult and complex area. The court must make one of the following orders: a hospital order with or without restrictions, a supervision order, or an order of absolute discharge. The sentencing will take into account the risk to society and the seriousness of the crime. The guidance stipulates that when assessing whether the offender's impairment or disorders will have an impact on sentencing, the court should take an individualistic approach and focus on the issues in the case. Levels of impairment caused by the condition will vary significantly between the individuals. The fact that the offender has an impairment or disorder should always be considered by the court, but it will not necessarily have an impact on sentencing for more serious offenses. The court must also bear in mind the protection of the public. Well, I hope you found today's video interesting, and information is power. Why not subscribe and watch more of our videos? If you need legal help, contact legal-minded friends.